the 7th interested party, Kituo cha Sheria, alongside Margaret Awor.
Please, Your Lordship, my name is Daniel Manso. I do appear for 3rd interested party.
My lords and my lady, if it may please the court, my name is Mudomi Thienkolu for the 2nd interested party, and I appear together with Mr. Moses Kipkogei, Mr. Kennedy Meli, Mr. Boniface Mwereru, Mr. Steve Ogola, and Mr. Kenson Mutethia.
May it please the court. I will introduce counsel appearing for the respondents in the interests of time. My name is Githu Muigai. I'm instructed by Christopher Marwa, President, who is instructed by the Honorable the Attorney General. For the National Assembly, 2nd and 9th respondent is represented by my learned colleagues, Eric Gumbo, Paul Nyamodi, Moses Kipkogei, Alex Baya, and Elias Ouma. For the Senate and the Speaker of the Senate, the 3rd and 4th respondents, my learned friend, Professor Tom Ojenda, appears with Mr. Mokele Moni and Ms. Thanji. Dr. Thionkolu has already introduced himself, and I will not repeat that. For the 9th respondent, Mr. Michael Mushemi. And Ms. Gafira is holding brief for Mr. Kamodo for the 10th respondents. Ms. Joy Anami and Hassan Noor are instructed by the 16th respondent, IEBC. Those are the appearances. Sorry, I would like to amend the representation of the Speaker of the National Assembly to include Mr. Sore, S-O-R-E-H, Sore. Those are the appearances. One.
Judgment. My name is Harrison Kinyanjui. With your very kind indulgence, I do appear for a petitioner in petition E586 of 2024. And my lords, my lady, we filed an application in the Court of Appeal to arrest the delivery of this judgment. This was after the 4th of June. The same petition was not heard when you had directed and ordered it be heard on this, on the 7th of June, 7th of May. You had ordered directed it be heard on the 4th. On that 4th, it was not even listed for a mention. It was listed for a hearing. Because your initial direction was that that petition should be heard as a standalone petition, so that then the decision that will be made in the consolidated petition, together with that, would now be the judgment of the court, because the Honorable Chief Justice had appointed your lordships and my lady as the bench in that petition and as a bench in this petition. Now, when on the 4th of June, the said hearing aborted, we filed an urgent application before the Court of Appeal. civil application number 291, E291 of 2026. I also wrote an email letter to the Chief Justice as the head of the judiciary to bring to her attention the precipitate injury and ruinous violation of the petitioner's right to be heard before you render yourselves in this petition. Accordingly, the Court of Appeal certified that application as urgent. This morning, I served on everyone, including all the parties that are before you now. That application relates to the Court of Appeal's jurisdiction under Article 165(3), and therefore, in deference to the authority of the Court of Appeal, the matter being sub judice in the Court of Appeal, to arrest the delivery of a judgment, so that then a judgment can be rendered that is encompassing that petition and the consolidated petitions. I had, in deference to Section 20, subsection 1H of the High Court Administration and Organization Act, informed the Deputy Registrar of this court that that application pertains to the arrest of the delivery of your judgment. And the Honorable Deputy Registrar then alerted me, asked me if I had communicated that to everybody, and I did. And therefore, in deference to the equivalent of the least pendants rule, that application being alive before the Court of Appeal, that this Honorable Court then defers the delivery of the judgment. My lords, as I close, my lady, the right to be heard, being enshrined in Article 25C of the Constitution, it is non-abrogable. It cannot be abridged. But if this judgment is rendered, and peradventure, you find, as indeed you would find, of 2024, that there was no impeachment, the constitutional threshold was never met, that petition, you nullify the impeachment, you render the decision according to the pleas of the petitioner in the amended petition, then your lordships, and my lady, if peradventure you were to dismiss the petitions, herein it would be very embarrassing. So I suggest, in deference to that constitutional authority of the Court of Appeal, that you defer the rendering of this judgment. We can be heard tomorrow, because we filed our submissions ready for the 4th of June in that E586. And then the ship can sail. You can render a judgment, whether to dismiss or grant. Thank you.
Do you have an order from the Court of Appeal on this issue?
The Court of Appeal, as a matter of judicial notice, my learned friends will be aware, has a way of disposing of any matter.
I don't think we are for argument. I've asked, do you have an order from the Court of Appeal stopping or arresting this judgment?
As we speak right now, no, because the order of business,
you have
the Court of
answered
Appeal.
me. You have answered me.
May I finish,
Judge? You have answered me, and I have accepted that answer. I will now ask some of the parties here to respond to that.
May I finish before they respond, just for good order? My lords and my lady, we do not in the list, I do not in the list, want to bring any theatrics or sabotage the administration of justice before you. What has provoked this particular move to the Court of Appeal is the aborting of the hearing on the 4th of June, 2026. And so that my learned friends can respond. On the 7th of May, before you, learned Senior Counsel Professor Agitho Mugai gave me the podium so that then you could address everybody in E586. On that day, you gave, in the presence of everybody here, the 4th of June as a hearing date. So that as they address that, it is common ground that that petition was to be heard before the date to render the judgment was given. Thank you, Your Lordships. And thank you for giving me this opportunity.
The subject matter raised by Mr. Kinyanjui relates to a file which is not before us here. And we have not taken any record in this particular file. But for the purpose of transparency, I will ask the parties who are expecting a judgment from us for their comment.
My lords, my ladies, I have the instructions from the team of the first petitioner, His Excellency Rigathi Gachagua, to make representations on his behalf. We have come here to pick the judgment in the petition before you. We have not received any order from the Court of Appeal stopping today's proceedings. We actually, as a matter of fact, not participating in that matter at the Court of Appeal, and therefore it will be very curious for us to have our legitimate expectations to get a judgment today interfere with a matter in which we are not participating. In the absence of a formal directive from a court higher than this, the Court of Appeal stopping this judgment, we ask you to deliver our judgment as scheduled today. That's all.
Thank you.
Of the 44th petitioners, my lord, I associate myself with the made by senior counsel. The fact that that file is not before you, my lord, forms the basis upon which this judgment can be deferred. And most importantly, my lord, counsel having not given sufficient reasons, my lord, for adjournment, my lord, or arresting the judgment, my lord, I think the legitimate expectations of the 4th to the 49th petitioners, my lord, is that you render yourself as you set your mind and yourselves to do this afternoon, my lord. We are opposed to that application.
Thank you.
In the interest of time, I will speak for all my colleagues, for the respondents, and we associate ourselves with the submission of learned senior counsel, Mr. Ongoya. Yes.
Thank you.
My lord, on behalf of the third interested party, we associate ourselves with the submissions of the lawyers for the petitioner, first petitioner, and wish that, my lord, you could deliver judgment as it has been agreed before. I thank you, my lord.
Thank you.
Your Honor, on behalf of the second petitioner, we associate ourselves with the submissions of the other petitioners, and we say in the absence of a court order for stay, then we see no need of stopping judgment. That's all.
My lords and my ladyship, appearing for the 43rd petitioner, we also associate ourselves with the submissions of Senior Counsel Ongoya, and in the absence